Welcome to the YouTube channel, Legal Remedies. In this edition of Legal Remedies, the point on which we are going to focus our attention today is the Communal Violence Bill of 2011. Was it meant to dispense uniform or preferential justice? Reading the fine print. Disclaimer. This video intends to make a critical analysis of the Prevention of Communal and Targeted Violence, Access to Justice and Reparations Bill 2011, which however, was withdrawn and never became a law, and how the bill, as such, was actually intended to offend, deviate, and derogate the settled principles of law, with respect to the concept of secularism. The video is for general information and public awareness purposes only. Secularism, in a democracy, is all about equality and fairness. In a secular democracy, all citizens are equal before the law and parliament. No religious or political affiliation gives advantages or disadvantages to anyone, and believers of all religions are citizens with the same rights and obligations. In the case of Zudin Burhanuddin Bukhari vs. Brij Mohan Ramdas Mehra, the Supreme Court of India went on to define the concept of secularism, by way of which the court set the role of the state to be neutral or impartial in extending its benefits to citizens of all castes and creed, and cast a duty on the state to ensure, through its laws, that disabilities are not imposed based on persons practicing or professing any particular religion. With the aforesaid view of a working democracy in India, and if we were truly following and practicing secularism, the Prevention of Communal and Targeted Violence, Access to Justice and Reparations Bill 2011, which was drawn and approved by the then National Advisory Council, would only expose the intent of dispensing justice, essentially preferential in nature. The very definition clauses ran on the basic premise that violence could only be deemed to be communal if such a violence were committed by a religious or linguistic majority on minority, and not vice versa. According to the bill, a victim was defined as a member of the minority group only. A pertinent instance could be that in India, where Hindu population is dominant, whereas Muslim or any other religious population is a minority, if a communal riot broke out, then only the members of the minority group could claim their right, and not otherwise. Furthermore, according to the bill, what qualified as hostile environment against a group meant and included any intimidating or coercive action by a majority against a minority group by virtue of his or her association with that group, and laid down circumstances wherein the said act could be deemed to be hostile environment. However, point or clause 5 created a very arbitrary standard for consideration as to what conduct could result into creation of the said hostile environment. The clause laid down that it would include any other act, whether or not it amounted to an offence under this act, that has the purpose or effect of creating an intimidating, hostile, or offensive environment. This was clearly and completely ambiguous as to which acts would precisely be identified as hostile and offensive as such. The most draconian of all provisions was the power which was intended to be conferred on the central government to construe any act of organized communal violence as internal disturbance within the meaning of Article 355 of the Constitution of India. According to the proposed law, the prerogative of determining whether an act qualified as being tantamount to internal disturbance solely vested with the central government under proposed Section 20. The very nature of emergency provisions bestows indomitable powers on the state, and this could always be used for political advantages. That would further impose a serious threat to the very nature of federal character of the country, as this provision intended to give all the powers in the hands of the central government, and the state government was left to be nothing but a mute spectator to the use of emergency powers of the central government, which extends to restricting even the fundamental rights of every individual in the interest of the state. Some of the pertinent questions that would arise, and were asked, were: why only minorities considered as victims? Whether the bill impinged upon the jurisdiction of the state to legislate, as the law and order, as such, fell into the domain of state? Was the timing of the bill, as such, was a poll gimmick to appease minorities to vote in favor of the Congress party? How does the intended law control the instance of communal violence? What data was collected to base the assumption of majority Hindus being the perpetrators of communal violence? Was the bill, as drawn, was precisely anti-Hindu, as was called by the Vishwa Hindu Parishad? Why did the bill assume that communal trouble created only by members of majority community, i.e. Hindus, and never by minorities? The bill, as drawn, was disastrous, and had all the ingredients of being against the core principles of a working democracy, as the intended law squarely tilted towards, or for that matter, in favor of the minorities, despite having been called a tool to protect the secular principles of the Constitution. And therefore, it is good that it never ultimately culminated into a law, and was finally withdrawn by the concurrent ruling dispensation. Thank you for watching the video. Please do not forget to subscribe to this channel to view upcoming discussions of similar nature, and please like, leave comments, and share this video so that others interested may have the benefit of the information. Also, please press the bell icon and get notified about the next releases.